bringing up the defendant? It's taking so long. On cue. All right, we're back on the record in State of Wisconsin versus Jacob Cayer, case number 2016 CF 902. The appearances remain the same as they did earlier today. I'm told that the jury has reached a verdict. Now, I just want to remind, it doesn't look like we have very many people here that I'm concerned about, but I just want to remind everybody that we have been at this for a few days. The jury is about to return their verdict consistent with our system of justice, and I would ask everyone to just take a moment to remember that we're in a courtroom, and I'm going to ask that there be no outbursts or disturbances of any kind that might affect the jury. Depending on their verdict, we may be going to a second phase, and I don't want the jury in any way affected by anything that might happen here today. They've been very conscientious, very hardworking, very diligent, so I'd ask you to be mindful of that as they return to the courtroom and we learn of their decision in this case. Please stand for the jury. I guess we could be seated for a moment. Apparently there was a need for some restroom usage or something that everyone wasn't ready to go. please stand? Please be seated. The jury has returned to the courtroom. Ladies and gentlemen of the jury, have you reached a verdict?
Yeah.
Would you please hand the verdict to the bailiff? The verdicts appear to be in proper form, and I will read the verdicts at this time. State of Wisconsin versus Jacob Cayer. We, the jury, find the defendant, Jacob P. Cayer, guilty of first-degree intentional homicide of Sabrina O. Teague as charged in count 1 of the information, dated at Green Bay, Wisconsin, this 12th day of August, 2020, signed by the foreperson. State of Wisconsin versus Jacob P. Cayer. We, the jury, find the defendant, Jacob P. Cayer, guilty of the first-degree intentional homicide of Heesun Teague as charged in count 2 of the information, dated at Green Bay, Wisconsin, this 12th day of August, 2020, signed by the foreperson. State of Wisconsin versus Jacob P. Cayer. We, the jury, find the defendant, Jacob P. Cayer, guilty of the attempted first-degree intentional homicide of Joel Kennedy as charged in count 3 of the information, dated at Green Bay, Wisconsin, this 12th day of August, 2020, signed by the foreperson. State of Wisconsin versus Jacob P. Cayer. We, the jury, find the defendant, Jacob P. Cayer, guilty of burglary as charged in count 4 of the information, dated at Green Bay, Wisconsin, this 12th day of August, 2020, signed by the foreperson. State of Wisconsin versus Jacob P. Cayer. We, the jury, find the defendant, Jacob P. Cayer, guilty of bail jumping as charged in count 5 of the information, dated at Green Bay, Wisconsin, this 12th day of August, 2020, signed by the foreperson. State of Wisconsin versus Jacob P. Cayer. We, the jury, find the defendant, Jacob P. Cayer, guilty of bail jumping as charged in count 6 of the information, dated at Green Bay, Wisconsin, this 12th day of August, 2020, signed by the foreperson. Before I accept the verdicts, I'll ask the jury if this verdict is your verdict and ask the jurors to raise their hands. If yes, ladies and gentlemen of the jury, is this your verdict? Everyone has raised their hand. Thank you. Do the attorneys want the jurors individually polled?
No, thank you, Judge.
Thank you. Thank you, ladies and gentlemen. We obviously proceed to phase 2, and we'll start that tomorrow. If you can all be back for 8:30, we'll start right at 8:30 tomorrow.
We did want to address timing, actually, before we
Okay.
instruct the jury on that.
Yes? How about we start a little bit later tomorrow? I think that was a yes? You want to start a little bit later? All right. Does 10 o'clock work? Report so that we can start at 10 o'clock? All right. So if you just try to come so that you can get through the courthouse entry screening by like 9. Come by 9:45 so you can be up here for 10. That should be plenty of time. All right, I'll dismiss you until then, ladies and gentlemen. And, you know, we've already had you deliberate on the issue that you've already decided, but there are additional issues tomorrow, so you're still part of this jury, and I would ask you not to discuss the case with anyone at this point until your service is completely over, and not do any research or anything. And we'll see you back tomorrow morning. Thank you. Please stand for the jury. Please be seated. Okay. Do we have anything to put on the record at this time? Any motions?
I guess I would move for a judgment on that verdict.
And we'll make a motion for judgment notwithstanding the verdict. Thank you.
Thank you. I'm not going to grant the defense motion. My question is whether I should be granting your motion at this time or waiting till the end of phase 2.
If the court wishes to hold that in abeyance until we get to the end of phase 2, that's
right.
fine. I mean, I think regardless, he would be found guilty.
Correct. It's
in
just a
phase one
matter of
those
the
counts.
other issues. So I will indicate that, for the record, that I am going to accept the jury verdicts and enter judgments accordingly, finding Mr. Cayer guilty of first-degree intentional homicide as charged in count 1 of the information, guilty of first-degree intentional homicide as charged in count 2 of the information, guilty of attempted first-degree intentional homicide as charged in count 3 of the information, guilty of burglary as charged in count 4 of the information, guilty of bail jumping as charged in count 5 of the information, and guilty of bail jumping as charged in count 6 of the information. And then we'll take up our issues regarding phase 2 tomorrow. Before you leave, I'd like to give you a printed copy of the proposed jury instructions so that maybe if we get that far tomorrow, that we don't have to take the jury's time to address that. And if you could be here for 9:45 tomorrow morning, then perhaps we could take up any issues ahead of time. All right, if there's nothing else, then we'll be in recess. Thank you. Thank you. I'd ask his attorney, but I don't think